ಸ್ವಲ್ಪ ಹಿಂದೆ ಕೂತವರೆಲ್ಲ ಮುಂದೆ ಬನ್ನಿ. ಐ ರಿಕ್ವೆಸ್ಟ್ ದಿ ಆಫೀಸರ್ಸ್ ಹೂ ಆರ್ ಸಿಟಿಂಗ್ ಆನ್ ದ ಬ್ಯಾಕ್ ಸೀಟ್, ಪ್ಲೀಸ್ ಕೇಮ್ ಇನ್ ದ ಫ್ರಂಟ್ ರೋಸ್. ಮುಂದಿನ 3 ಬಿಟ್ಟು ಹಿಂದೆ ಕೂತ್ಕೊಳ್ಳಿ. ಹಿಂದೆ ಬನ್ನಿ, ಎದ್ದು ಬನ್ನಿ, ಮುಂದೆ ಖಾಲಿ ಬಿಡಬೇಡಿ. ನಿಮಗೆ ಹೇಳ್ತಾ ಇರೋದು ನಾವು, ಮುಂದೆ ಬನ್ನಿ, ಎಲ್ಲರೂ ಬನ್ನಿ. ಬರೀ 3 ರೋ ಬಿಟ್ಟು ಕೂತ್ಕೊಳ್ಳಿ ಅಂತ. ಲಾಸ್ಟ್ 3 ಲೈನ್ಸ್ ಅವ್ರು ಇದ್ದಾರೆ, ಮುಂದೆ ಬನ್ನಿ. ಈ ಕಡೆ ಮುಂದೆ ಬನ್ನಿ, ಪ್ಲೀಸ್ ಕಮ್. ಲಾಸ್ಟ್ 3 ರೋಸ್. ಅಲ್ಲಿ ಹೋಗಿ ವ್ಯವಸ್ಥೆ.
Hello, check. Hello, check, mic check.
The Honorable Chief Minister of Karnataka, Shri Rajendra, has arrived at the venue.
ಕರ್ನಾಟಕದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂತಹ ಶ್ರೀಯುತ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿಯವರು ಇದೀಗ
ಹಿಂದೆ ಹೋಗ್ಬೇಕು ಫಸ್ಟ್ ಹಿಂದೆ ಹೋಗ್ಬೇಕು. ಸ್ವಲ್ಪ ಮುಂದೆ ಬರ್ಬೇಕು, ಹಿಂದೆ ಬರ್ಬೇಕು.
ಸಾಕಿಲ್ಲ
ನೆಕ್ಸ್ಟ್ ಆಗಿದೆ.
Honorable Dr. Justice Dhananjaya Y. Chandrachud, Judge Supreme Court of India, has arrived.
Honorable Shri Justice Ruturaj Avasthi, Chief Justice High Court of Karnataka, is also with us today.
We now request Honorable Dr. Justice Dhananjaya Y. Chandrachud to kindly come over.
ಶ್ರೀ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿಯವರು ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಕರ್ನಾಟಕ ರಾಜ್ಯ ದಯಮಾಡಿ ವೇದಿಕೆಗೆ ಆಗಮಿಸಬೇಕು ಅಂತ ಕೋರಿಕೆ.
Honorable Shri Justice A.S. Bopanna, Judge Supreme Court of India.
Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, I request her to kindly come.
I think the dignitaries will arrive after this photograph.
Honorable Shri Justice Ruturaj Avasthi, Chief Justice High Court of Karnataka, to kindly come onto the dais. Registrar General of High Court and all the office bearers of the association are requested to come on the dais.
Request Shri Mallanagowda, President, Jai Prakash DR, General Secretary, to kindly bring in the dignitaries onto the stage, please. Honorable Shri Dr. Justice Dhananjaya Y. Chandrachud on stage, Shri Basavaraj Bommai, Honorable Chief Minister of Karnataka, Honorable Shri Justice A.S. Bopanna,
Honorable Srimati Justice B.V. Nagaratna, Honorable Shri Justice Ruturaj Avasthi, Chief Justice High Court of Karnataka,
and Mallanagowda, the President, and Shri Jai Prakash DR, General Secretary. At the outset, ದಯಮಾಡಿ ಎಲ್ಲರೂ ಎದ್ದು ನಿಲ್ಲಬೇಕಾಗಿ ವಿನಂತಿ.
ನಾಡಗೀತೆಯೊಂದಿಗೆ ಕಾರ್ಯಕ್ರಮದ ಶುಭಾರಂಭ. ಶ್ರೀಯುತ ಸರವಣನ್ ಹಾಗೂ ಪ್ರತಿಭಾ ಡಿಎಸ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಇದೀಗ ನಾಡಗೀತೆಯನ್ನು ಪ್ರಸ್ತುತಪಡಿಸ್ತಾ ಇದ್ದಾರೆ.
We request all of you to kindly rise.
ಹಸುರಿನ ಗಿರಿಗಳ ಸಾಲೆ ನಿನ್ನಯ ಕೊರಳಿನ
Thank you very much, Sri Saravanan and Pratibha TS, judicial officers, for the soulful rendition of Nadagite.
ನಮಸ್ಕಾರ, ಶುಭೋದಯ. ವಿಶ್ವಕವಿ ರವೀಂದ್ರನಾಥ ಟಾಗೂರರ ಪ್ರಸಿದ್ಧ ಕವನ ವೇರ್ ದೆರ್ ಇಸ್ ನೋ ಫಿಯರ್ ಫಾರ್ ಮೈಂಡ್ ಇದರ ಕನ್ನಡ ಅನುವಾದದಲ್ಲಿ ಬರುವ ಒಂದು ಸಾಲು ಹೀಗಿದೆ: ಎಲ್ಲಿ ತಿಳುಹಿಗೆ ಯಾವ ಬಂಧನದ ತಡೆ ಇರದೋ ಅಲ್ಲಿ ಆ ಸ್ವರ್ಗದಲ್ಲಿ ತಂದೆಯೇ ಈ ನನ್ನ ನಾಡು ಎಚ್ಚರಿರಲಿ. ಅದೇ ತಿಳುಹಿನ ನಾಡೊಂದನ್ನು ಸೃಷ್ಟಿಸುವ ಪ್ರಯತ್ನ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಅಸೋಸಿಯೇಷನ್ದಾಗಿದೆ. ಲೇಡೀಸ್ ಆ್ಯಂಡ್ ಜೆಂಟಲ್ಮೆನ್, ಫ್ರಮ್ ಇಟ್ಸ್ ಇನ್ಸೆಪ್ಷನ್, KSJOA is striving continuously and constantly to create a better atmosphere of justice and its deliverance. ನ್ಯಾಯವಾದ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಸರಳೀಕರಿಸುವತ್ತ, ಹೊಸ ಸಾಧ್ಯತೆಗಳಿಗೆ ತಮ್ಮನ್ನು ತೆರೆದುಕೊಳ್ಳುವ ಮತ್ತು ಆಧುನಿಕ ವ್ಯವಸ್ಥೆಯ ಮುಖೇನ ಸಮಯೋಚಿತ ನ್ಯಾಯ ವಿತರಣೆಯ ಧ್ಯೇಯದೊಂದಿಗೆ KSJOA 20ನೇ ದ್ವೈವಾರ್ಷಿಕ ಸಮ್ಮೇಳನ ಇಂದು ಆಯೋಜಿಸಿದೆ.
Yes, indeed, ladies and gentlemen, in order to promote the social and intellectual advancement of the members of the association, the current executive committee has conceived the 20th Biennial State-Level Conference of Judicial Officers. As we are all aware, we all live in the digital world today. Everything, you name it, you see it, you feel it, is digital. Hence, the theme is rightly chosen as digitalized and modern judiciary for effective and timely justice. On behalf of the President and the members of the Karnataka State Judicial Officers Association, Bengaluru, I am Shankar Prakash.
ನಾನು ವೀಣಾ ಶರ್ಮಾ.
We welcome you all to the inaugural function of the 20th Biennial State-Level Conference of Judicial Officers. ತಮಗೆಲ್ಲರಿಗೂ ಈ ವಿಶೇಷವಾದ ಕಾನ್ಫರೆನ್ಸ್ಗೆ ಉದ್ಘಾಟನಾ ಸಮಾರಂಭಕ್ಕೆ ಆದರದ ಸ್ವಾಗತ, ಸುಸ್ವಾಗತ, ladies and gentlemen. At the outset, I would request the President of the Association, Shri Mallanagowda, for the opening remarks and welcome address. ಬಂಧುಗಳೇ, ಸ್ವಾಗತಿಸಿ ಶ್ರೀ Mallanagowda.
A very pleasant good morning to everybody present in this inaugural function of 20th Biennial State-Level Conference of Judicial Officers of the State of Karnataka. My Lord, Honorable Dr. Justice Dhananjay Y. Chandrachud, Judge, Supreme Court of India. Sri Basavaraj Bommai, Honorable Chief Minister, Government of Karnataka. My Lord, Honorable Sri Justice A.S. Bopanna, Judge, Supreme Court of India. My Lord, Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India. My Lord, Honorable Sri Justice Rituraj Avasti, Chief Justice, High Court of Karnataka. Honorable former Judges of Supreme Court of India. Honorable sitting and former Judges of High Court of Karnataka. My brother and sister judicial officers from various parts of Karnataka. Respected resource persons of this conference, representatives of print and electronic media, distinguished invitees, guests, ladies and gentlemen. The Karnataka State Judicial Officers Association is a registered association representing all the judicial officers in the state, from the cadre of entry-level civil judge till district judge super time scale, presently consisting of 1,082 members. The association was formed with the aims and objectives embodied in the Memorandum of Association inter alia to organize and unify all the judicial officers with a view to establish strong, fearless and independent judicial service capable of maintaining high standards and traditions associated with the judiciary. Our association was born on 26th October 1974 by subscribing to Memorandum of Association. Since then, our association has taken constant and concrete steps for the well-being of the judicial officers in the state. Our association has been holding biannual state-level conference of judicial officers for social and intellectual advancement of all the members of the association. First ever conference was held in the year 1988 at Belagavi. So far, 19th biannual state-level judicial officers conferences have been held in Bengaluru and other parts of the state. In order to promote social and intellectual advancement of the members of the association, this time we have organized this 20th biannual state-level conference of judicial officers today and tomorrow, consisting of 5 business sessions and other programs. The 2 days conference focused on various subjects of contemporary importance for the academic sessions. Our association, through this conference, is making an endeavor to craft progressive changes in the approach to deliver qualitative, responsive, effective and timely justice. Theme of this conference is Digitalized and Modern Judiciary for Effective and Timely Justice. This conference creates a platform for all-inclusive, informative, pragmatic, tech-savvy judicial system. Delivery of effective and timely justice needs application of advanced technology and having regard to change in use of technology by the litigant public. In order to discuss about the application of advanced technology effectively in justice delivery system, a session has been devoted on the subject Advanced Technology for Justice Delivery, its applicability and challenges ahead. As the world is changing, the judiciary has to keep pace with the change in the expectations of the society and needs of the vulnerable. Hence, another session is devoted to the subject Role of Judiciary in a Changing World, the topic which was the theme for the International Judicial Conference 2020 held at New Delhi. Once Nelson Mandela said, I quote, "Education is the most powerful weapon which can be used to change the world," unquote. The judiciary in India has always taken a pragmatic approach in dispensation of justice to the people of this country. Change is always a catalyst for increasing the efficiency and achievement. The Karnataka judiciary has always been in the forefront in this regard. This will change image of the judiciary as a people-friendly institution in the democratic setup. Hence, the proposed conference. Honorable Dr. Justice Dhananjay V. Chandrachud is the chairperson of E-Committee, Supreme Court of India, and his Lordship is very much interested in adopting advanced technology in justice delivery system. While delivering keynote address in a recent workshop held at Dubai, his Lordship has expressed the view, I quote, "Law and arbitration must keep pace with technological advancement and increasing use of artificial intelligence in daily life to enable the existing adjudicating system to decide the new age dispute," I unquote. This shows that his Lordship is also of the opinion that application of the advanced technology in the system of adjudication is very important need of hour. We are honored to have his Lordship to inaugurate this conference. So, we the office bearers of the association, through Honorable Chief Justice of Karnataka, invited his Lordship, Honorable Dr. Justice Dhananjay V. Chandrachud, Judge Supreme Court of India, and Chairperson E-Committee, Supreme Court of India, to inaugurate this conference. His Lordship has kind-heartedly accepted our invitation. His Lordship is kind enough to be present amongst us today to inaugurate today's conference. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to His Lordship. Welcome, my Lord. The government of Karnataka, headed by Honorable Chief Minister Sri Basuraj Bommai, has always responded to the needs of the judiciary, and it has been taking steps to the welfare of the judges by implementing the proposals of Honorable High Court of Karnataka. When the office bearers requested Honorable Chief Minister to be the guest of honor for today's conference, he readily accepted our invitation and requested us to submit our representation with regard to grievance and need of the judicial officers. It shows his concern to the judiciary. At this juncture, I wish to extend my deep appreciation to the Government of Karnataka for supporting the efforts of the judiciary in dispensing quality justice. I, on my behalf and on behalf of all the judicial officers of state, extend warm and affectionate welcome to Honorable Chief Minister Sri Basuraj Bommai. I welcome you, sir. When the office bearers of the association requested His Lordship Sri Dinesh Maheshwari, Judge Supreme Court of India, His Lordship has kindly accepted our invitation to participate in the conference and grace the occasion. However, yesterday he has sent a message to the office, to the president of the association, expressing that due to unavoidable circumstances, His Lordship is unable to attend the function and wish the best wishes to grand success of the conference and meaningful deliberations. While wholehearted by thanking His Lordship for the kind wishes, we greatly acknowledge the kind message sent by His Lordship. When the office bearers of the association requested His Lordship Honorable Justice A.S. Bopanna, Judge Supreme Court of India, His Lordship has kind-heartedly accepted our invitation to grace this occasion. His Lordship's tenure as Judge of our own High Court will always be remembered with great pride and honor by each one of us. On my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to His Lordship. Welcome, my Lord. when the office bearers of the association requested her ladyship, Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, to grace the occasion, her ladyship has kind-heartedly accepted our invitation to grace the occasion. While her ladyship was the judge of Karnataka High Court, her ladyship was very generous to all the judicial officers and was always kind towards the cause of the judicial officers. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to her ladyship. Welcome, my lord. Our Honorable Chief Justice, Sri Rituraj Avasti, is a philosopher and guide to our association in all our endeavors, including organizing this conference. His Lordship's encouragement and kind advice in organizing this event is praiseworthy. His Lordship always acts like Karta of the family. When the office bearers of the association requested His Lordship to preside over the inaugural function of the conference, His Lordship has happily accepted our invitation and presiding over the function. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to His Lordship. Welcome, my lord. The Honorable sitting judges of the High Court of Karnataka have guided us in organizing this conference. Without their guidance and support, organizing this conference could not have been possible. On our request, all the Honorable sitting judges of Honorable High Court are present amongst us today. I, on my behalf and on behalf of all the judicial officers of the Karnataka state, extend warm and affectionate welcome to all the Honorable sitting judges of Honorable High Court. Honorable former judges of Honorable Supreme Court and Honorable High Court of Karnataka are our strength in organizing all the biennial conferences successfully from the first conference till this day. On our request, Honorable former judges of Supreme Court and Honorable High Court are present to grace the occasion. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to all the Honorable former judges of Honorable Supreme Court and Honorable High Court of Karnataka. The bar and bench are the two faces of the same coin. Learned advocates of the bar play an important role in dispensation of qualitative and timely justice. Responding to our invitation, many of the advocates and representatives of the association are present today. I, on behalf of all the judicial officers of the Karnataka state, extend warm and affectionate welcome to all of them. On our request, the former members of our association are also present in this function to grace this occasion. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to all the retired judicial officers. The resource persons of the sessions have contributed their valuable time and knowledge for the conference, and they are also present in today's conference. I welcome them all to this conference. This conference can be successful only with the active and effective participation of all the delegates present here from various parts of our state. I am sure that this conference will enrich all the delegates. I welcome all the delegates to this conference. The print and electronic media has a responsible and important role in a country like ours by making people aware of events like present conference through proper broadcast. The representatives of the print and electronic media are present in this function. I, on my behalf and on behalf of all the judicial officers of the state, extend warm and affectionate welcome to them. I extend my sincere and warm welcome to the staff of all the courts at Bengaluru for their presence and dedication in assisting us in organizing this conference. The Vice Chancellor of GKVK, the police officers, the Deputy Commissioner of Bengaluru, officers of the Health Department, heads and officers of many other departments, and all other invitees are present in this conference. I extend warm and affectionate welcome to all of them also. Before parting with my welcome address, on behalf of the association, I most humbly and respectfully submit to the honorable dignitaries on the dais that it is often said that the office of judge is not the matter of status and authority, but it is a pious responsibility to be discharged with great care, concern, and compassion. The common man considers the judiciary as an ultimate guardian of his rights and liberties. The welfare of the judicial officers and their family members is also equally important. We, the members of KSJOA, are anxiously waiting for the implementation of the recommendations of Honorable Second National Judicial Pay Commission, as the same is overdue for review. This is because only when we are free from financial worries, we will be able to give our best. Lastly, I extend my sincere warm welcome to one and all who are present here. Jai Hind, Jai Karnataka.
ದೇಶದ ನ್ಯಾಯಾಂಗವು ಭಾರತದ ಎಲ್ಲ ಪ್ರಜೆಗಳಿಗೆ ನ್ಯಾಯ ವಿತರಣೆ ಸಕಾಲದಲ್ಲಿ ಆಗಬೇಕು ಎನ್ನುವ ಘನ ಉದ್ದೇಶವನ್ನಿರಿಸಿಕೊಂಡು ಸದಾ ಕಾರ್ಯತತ್ಪರವಾಗಿದೆ. ಹೊಸ ಚಿಂತನೆಗಳು, ಆಧುನಿಕ ತಂತ್ರಜ್ಞಾನದ ನೆರವು, ಹೀಗೆ ನಿರಂತರ ಬದಲಾವಣೆಗಳ ಜೊತೆಗೆ ತನ್ನ ಕಾರ್ಯಕ್ಷಮತೆಯನ್ನು ಹೆಚ್ಚಿಸಿಕೊಳ್ಳಬೇಕಾದ ಜವಾಬ್ದಾರಿ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಅಸೋಸಿಯೇಷನ್ನದ್ದಾಗಿದೆ. ಇಲ್ಲಿ ಈ ಒಂದು ಉದ್ದೇಶವನ್ನು ದೃಢೀಕರಿಸಲು ಆಯೋಜಿತಗೊಂಡಿರುವ ಈ ಸಮ್ಮೇಳನಕ್ಕೆ ಆಗಮಿಸಿರುವ ಎಲ್ಲ ಅತಿಥಿ ಗಣ್ಯರನ್ನು, ಸಭಾಸದರನ್ನು ಆತ್ಮೀಯವಾಗಿ ಸ್ವಾಗತಿಸಿದಂತಹ ಶ್ರೀಯುತ ಮಲ್ಲನಗೌಡ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
Bandhugale, it's indeed a matter of great privilege and pleasure to offer floral welcome to the dignitaries. I would request Shri T.G. Shivshankare Gowda, Registrar General, High Court of Karnataka, to kindly offer a bouquet to Honorable Dr. Justice Dhananjaya Y. Chandrachud, Judge, Supreme Court of India, and Chairperson, E-Committee, Supreme Court of India. Bandhugale, Nimma Kartadanu, let's welcome the Honorable Dr. Justice Dhananjaya Y. Chandrachud.
Shriyuta Malanagonda, President of the Association, I request him to kindly offer a bouquet to Shri Basavaraj Bommai, Honorable Chief Minister of Government of Karnataka.
ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಸ್ವಾಗತ. Now request Shri Umesh HK, a Treasurer of the Association, to kindly offer a bouquet to Honorable Shri A.S. Bopanna, Judge, Supreme Court of India.
I request Srimati B.N. Sujata, Vice President of the Association, to kindly offer a bouquet to Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India.
Honorable Srimati Justice B.V. Nagaratna avarige swagata suswagata. And I would now request Shri Babu N., Joint Secretary of the Association, to kindly welcome Honorable Shri Justice Rituraj Avasti, the Chief Justice of High Court of Karnataka. Bandhugale, swagatisi Honorable Shri Justice Rituraj Avasti.
ಗಣ್ಯರಿಗೆ ಹೂಗುಚ್ಛದ ಸ್ವಾಗತವನ್ನು ಕೋರಿದಂತಹ ಎಲ್ಲರಿಗೂ ಸಹ ಧನ್ಯವಾದಗಳು. ಆರೋಗ್ಯಕರವೂ ಶಾಂತಿಯುತವೂ ಆದ ಬಲಿಷ್ಠ ಸಮಾಜವೊಂದರ ನಿರ್ಮಾಣ ಎಲ್ಲ ರಾಷ್ಟ್ರಗಳ ಮೂಲಭೂತ ಉದ್ದೇಶ. ಆ ಕಾರ್ಯದಲ್ಲಿ ನಿರಂತರವಾಗಿ ಮುನ್ನಡೆಸುವ, ದಾರಿ ತೋರುವ ಬೆಳಕಿನ ಶಲಾಕೆಯೊಂದು ನಮ್ಮೊಡನಿರಲಿ. ಆ ನ್ಯಾಯದ ಬೆಳಕು ಸರ್ವರ ಮೇಲೆ ಪ್ರತಿಫಲಿಸಲಿ, ಸರ್ವವ್ಯಾಪಿಯಾಗಿ ಬೆಳಗಲಿ ಎಂಬ ಸದಾಶಯದೊಡನೆ ಇದೀಗ ಸಮ್ಮೇಳನದ ಶುಭಾರಂಭ ಜ್ಯೋತಿ ಬೆಳಗುವುದರ ಮುಖೇನ.
On behalf of all of us, it's my pleasure to request the Honorable Dr. Justice Dhananjaya Y. Chandrachud and other dignitaries to kindly move forward and light the lamp to signal the inauguration of the 20th Biennial State Level Conference of Judicial Officers. Bandhugale, ಈ ಒಂದು ದೀಪವನ್ನು ಬೆಳಗಿಸೋದ್ರ ಮುಖೇನ ಅಸೋಸಿಯೇಷನ್ ಮತ್ತಷ್ಟು ಶಕ್ತಿಯುತವಾಗಿ ಬೆಳೆಯಲಿ, ಇನ್ನಷ್ಟು ಹೆಮ್ಮರವಾಗಿ ಬೆಳೆದು ನಾಡಿನ ಸಮಸ್ತ ಜನತೆಗೆ ನ್ಯಾಯವನ್ನು ಒದಗಿಸುವಂತಹ ನಿಟ್ಟಿನಲ್ಲಿ ಅಹರ್ನಿಶಿ ಕೆಲಸ ಮಾಡಲಿ ಅನ್ನುವಂತಹ ಹಾರೈಕೆ Honorable Dr. Justice Dhananjaya Y. Chandrachud and the dignitaries. It's indeed to impart justice to each and every one of the society.
ನ್ಯಾಯದ ಪಥ ಸದಾ ವಿಜೃಂಭಿಸಲಿ ಎಂಬ ಸದಾಶಯದೊಂದಿಗೆ ಆಯೋಜಿತವಾದಂತಹ ಈ ಸಮ್ಮೇಳನದಲ್ಲಿ ಬೆಳಗುತ್ತಿರುವ ನಂದಾದೀಪ ಎಂದೂ ನಂದದ ನಂದಾದೀಪವಾಗಲಿ ಎಂದು ನಾವೆಲ್ಲ ಆಶಿಸೋಣ.
Going in line with the theme, it's the modern judiciary for effective and timely justice, and digitalization will go a long way towards helping in imparting the justice. Lighting of the lamp by the Honorable Chief Minister Shri Basavaraj Bommai now. Sincere thanks to all the dignitaries for lighting the lamp for the formal inauguration.
ಕಾರ್ಯಕ್ರಮವನ್ನು ಉದ್ಘಾಟಿಸಿದ ಎಲ್ಲ ಗಣ್ಯರಿಗೂ ಸಹ ಧನ್ಯವಾದಗಳು.
We'll now have the felicitation to the dignitaries. I would request Shri Anil B. Katti, Principal City Civil and Sessions Judge, Bengaluru, Shri T.G. Shivshankare Gowda, Registrar General, High Court of Karnataka, Shri S.B. Vastramat, Principal District and Sessions Judge, Mandya, Shri Ramachandra D. Hudar, Director, Karnataka Judicial Academy, Bengaluru, Shri C.M. Joshi, Principal District and Sessions Judge, Belagavi, Shri Mallanagowda, President of the Association, to kindly felicitate Honorable Dr. Justice Dhananjaya Y. Chandrachud, who has taken time off in spite of his busy schedule to be here, Judge Supreme Court of India and Chairperson, E-Committee Supreme Court of India. Samasta Association in Parvagi, Gauravanvita Honorable Dr. Justice Dhananjaya Y. Chandrachudge, Gauravarpane.
ಸಮ್ಮೇಳನಕ್ಕೆ ಆಗಮಿಸಿರ್ತಕ್ಕಂತಹ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂತಹ ಶ್ರೀಯುತ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿಯವರಿಗೆ ಇದೀಗ ಗೌರವ ಸಮರ್ಪಣೆ. ಈ ಕಾರ್ಯವನ್ನು ನಿರ್ವಹಿಸೋದಕ್ಕೆ ಶ್ರೀ ಜಿ ಬಸವರಾಜ್, ಪ್ರಿನ್ಸಿಪಲ್ ಜಡ್ಜ್, ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಬೆಂಗಳೂರು, ಶ್ರೀ ಎಸ್ ವೈ ವಟವಟಿ, ರಿಜಿಸ್ಟ್ರಾರ್, ವಿಜಿಲೆನ್ಸ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಬೆಂಗಳೂರು, ಶ್ರೀಮತಿ ಬಿ ಎನ್ ಸುಜಾತ, ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ದ ಅಸೋಸಿಯೇಷನ್, ಶ್ರೀ ಜಿ ಎಸ್ ಸಂಗರೇಶಿ, ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ತುಮಕೂರು, ಶ್ರೀ ವೆಂಕಟೇಶ್ ನಾಯಕ್ ಟಿ, ಪ್ರಿನ್ಸಿಪಲ್ ಲಾ ಸೆಕ್ರೆಟರಿ ಗವರ್ನಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ಶ್ರೀ ಉಮೇಶ್, ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ಧಾರವಾಡ,
ಉಮೇಶ್ ಮಂಜುನಾಥ್ ಭಟ್ ಅಡಿಗ, ಇವರೆಲ್ಲರೂ ಸಹ ಈಗ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿ ಅವರಿಗೆ ಗೌರವವನ್ನು ಸನ್ಮಾನವನ್ನು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. We now request Srimati K.B. Geeta, Member Karnataka Administrative Tribunal, Bengaluru, Shri Muralidhara Pai, Principal District and Sessions Judge, Dakshina Kannada, Mangaluru, Shri Umesh H.K., Treasurer of the Association, Shri B.S. Nayak, Principal District and Sessions Judge, Chikkaballapura, Shri Manjunath Nayak, Registrar, Recruitment High Court of Karnataka, Bengaluru, and Shri Jai Prakash D.R., General Secretary of the Association, to kindly honor Honorable Shri A.S. Bopanna, Judge, Supreme Court of India. Idiga, Honorable Shri A.S. Bopanna, Judge, Supreme Court of India, avರಿಗೆ
ಗೌರವ ಸಮರ್ಪಣೆ. ಮುಂದೆ ಗೌರವಾನ್ವಿತ ಶ್ರೀಮತಿ ನ್ಯಾಯಮೂರ್ತಿ ಬಿ ವಿ ನಾಗರತ್ನ, ಜಡ್ಜ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಇವರಿಗೆ ಗೌರವ ಸಮರ್ಪಣೆ. ಈ ಕಾರ್ಯವನ್ನು ನೆರವೇರಿಸೋದಕ್ಕೆ ಶ್ರೀಮತಿ ಪ್ರಭಾವತಿ ಎಂ ಹಿರೇಮಠ್, ಚೀಫ್ ಜಡ್ಜ್, ಕೋರ್ಟ್ ಆಫ್ ಸ್ಮಾಲ್ ಕಾಸಸ್ ಬೆಂಗಳೂರು, ಶ್ರೀಮತಿ ಮಹಾಲಕ್ಷ್ಮಿ ನೇರ್ಲೆ, ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ಗದಗ್, ಶ್ರೀಮತಿ ಶುಭಾ ಗೌಡರ್, ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ಚಿಕ್ಕಮಗಳೂರು, ಶ್ರೀಮತಿ ಸೈದು ನಿಸಾ, ರಿಜಿಸ್ಟ್ರಾರ್, ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಆ್ಯಂಡ್ ಮೇಂಟೆನೆನ್ಸ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ಶ್ರೀ ಶಿವಣ್ಣ, ಪ್ರಿನ್ಸಿಪಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ಹಾಸನ್, ಶ್ರೀ ಬಾಬು ಎನ್, ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿ ಆಫ್ ದ ಅಸೋಸಿಯೇಷನ್.
Thank you very much, Honorable Srimati Justice B.V. Nagaratna, for accepting the felicitation. And now, ladies and gentlemen, we request the Honorable Sri Justice Rituraj Avasthi, Chief Justice of High Court of Karnataka, to accept the felicitation from Srimati B.V. Renuka, Registrar, Review and Statistics, High Court of Karnataka, Sri M.L. Raghunath, Principal District and Sessions Judge, Mysuru, Srimati Katyayani, District Judge and Executive Committee Member, Srimati Mangoli Premavati, Principal District and Sessions Judge, Chitradurga, Shri Mallikarjuna Gowda, Presiding Officer, Karnataka State Transport Appellate Tribunal, Bengaluru, Shri T.N. Inavalli, Principal District and Sessions Judge, Bengaluru Rural District, Bengaluru, to kindly felicitate Honorable Sri Justice Rituraj Avasthi, Chief Justice, High Court of Karnataka.
ಸನ್ಮಾನವನ್ನು ಸ್ವೀಕರಿಸಿದಂತಹ ಸನ್ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗೆ ಹೃತ್ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು. ಗೌರವವನ್ನು ಸ್ವೀಕರಿಸಿದಂತಹ ಎಲ್ಲ ಅತಿಥಿ ಗಣ್ಯರಿಗೂ ಸಹ ಹೃತ್ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು.
Well, ladies and gentlemen, the Honorable Chief Minister of Karnataka, Shri Baswaraj Bommai, has been striving that each and every citizen of this state will get justice and lead a very happy life. It's indeed our pleasure to request the Honorable Chief Minister, Shri Baswaraj Bommai, to kindly address all of us. Bandhugale, swagatisi Karnataka Rajyada Sanmanya Mukhyamantриಗಳಾದ Shri Baswaraj Bommai ಅವರನ್ನು.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಇಪ್ಪತ್ತನೆಯ ಬೈಎನಿಯಲ್ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಕಾನ್ಫರೆನ್ಸ್ ಆಫ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಈ ಉದ್ಘಾಟನೆ ಸಮಾರಂಭದಲ್ಲಿ ಭಾಗವಹಿಸಿ ಉದ್ಘಾಟನೆಯನ್ನು ನೆರವೇರಿಸಿಕೊಟ್ಟಂಥ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರು, ಭಾರತದಲ್ಲಿ ಬಹಳ ನ್ಯಾಯಾಧೀಶರಂತ ಹೆಸರು ಮಾಡಿರುವಂಥ ಶ್ರೀ ಧನಂಜಯ ಚಂದ್ರಚೂಡ್ಜಿ, ನಮ್ಮವರೇ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರು, ಅಷ್ಟೇ ನ್ಯಾಯನಿಷ್ಠರವಾಗಿ ಅವರ ಜಡ್ಜ್ಮೆಂಟ್ಗಳಲ್ಲಿ ನಾವು ನೋಡಿರುವಂಥದ್ದು ಜಸ್ಟಿಸ್ ಬೋಪಣ್ಣಜಿ, ಅತ್ಯಂತ ವಿರಳವಾಗಿರುವಂಥ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನಲ್ಲಿ ಹೆಣ್ಣು ಮಕ್ಕಳ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಜಸ್ಟಿಸ್ರಲ್ಲಿ ಒಬ್ಬರು, 4ರಲ್ಲಿ ಒಬ್ಬರಾಗಿರುವಂಥ ನಮ್ಮವರೇ ಆದಂಥ ಜಸ್ಟಿಸ್ BV ನಾಗರತ್ನಜಿ, ನಮ್ಮವರೇ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಕರ್ನಾಟಕ ಶ್ರೀ ಜಸ್ಟಿಸ್ ರಿತುರಾಜ್ ಅಶ್ವಥ್ಜಿ, KSJOAದ ಅಧ್ಯಕ್ಷರಂಥ ಮಲ್ಲನಗೌಡ್ರೆ, ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಆದಂಥ ಜಯಪ್ರಕಾಶ್ ಅವರೇ, ನೆರೆದಿರುವಂಥ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಅವರೇ ಮತ್ತು ರಾಜ್ಯದಿಂದ ಬಂದಿರುವಂಥ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ಜುಡಿಷಿಯಲ್ ಆಫೀಸ್ ಬಂಧುಗಳೇ, ಮಾಧ್ಯಮದ ಸ್ನೇಹಿತರೆ, ಸಾಮಾನ್ಯವಾಗಿ ನಾವು ಮಾತನಾಡುವಂಥ ವೇದಿಕೆಗಳು, ಸಭೆ ಮತ್ತು ಈ ಸಭೆಗೆ ಭಾಳ ವ್ಯತ್ಯಾಸ ಇದೆ. ಭಾಳ ಸತಿ ನಾವೆಲ್ಲ ಮಾತಾಡಿದ ಮೇಲೆ ಅಲ್ಲಿ ಯೋಚನೆಗಳನ್ನು ಪ್ರಾರಂಭ ಮಾಡ್ತೀವಿ, ಆದರೆ ಇಲ್ಲಿ ಯೋಚನೆಯನ್ನು ಮಾಡಿ ಮಾತನಾಡಬೇಕಾಗ್ತದೆ. ಸರ್, ಐ ವಾಸ್ ಜಸ್ಟ್ ಮೆನ್ಷನಿಂಗ್ most of our meetings we just talk and then start thinking about it, but here we have to think and talk. ಬಹಳ ಸಂತೋಷ ಆಗ್ತದೆ ತಮ್ಮನ್ನೆಲ್ಲ ನೋಡಿ, ಮತ್ತು ಅಷ್ಟೇ ಹೆಮ್ಮೆನೂ ಕೂಡ ಆಗ್ತದೆ. ನಾವು ನೀವು ಒಂದೇ ನೆಲೆಗಟ್ಟು, ಒಂದೇ ಸಮಾಜದಿಂದ ಬಂದಿದ್ದೇವೆ, ಒಂದೇ ಹಿನ್ನೆಲೆಯಲ್ಲೂ ಕೂಡ ಬಂದಿದ್ದೇವೆ. ಬಟ್ ಅವರ್ ಪ್ರೊಫೆಷನಲ್ಸ್ ಲೀಡ್ ಟು ಡಿಫ್ರೆಂಟ್ ಪಾತ್. ಆ ಸಂದರ್ಭದಲ್ಲಿ ತಾವು ಆಯ್ಕೆ ಮಾಡಿರುವಂಥ ದಾರಿ, ಸ್ಥಾನ, ಕರ್ತವ್ಯ ಇದನ್ನು ನೋಡಿದಾಗ ಈ ಸಮಾಜದಲ್ಲಿ ಇನ್ನೂ ಕೂಡ ಬಹಳಷ್ಟು ಜನ ಇಡೀ ಸಮಾಜವನ್ನು ಸ್ವಚ್ಛಗೊಳಿಸುವಂಥ, ಸಮಾಜದಲ್ಲಿ ನ್ಯಾಯ ಒದಗಿಸುವಂಥ, ಸಮಾಜದಲ್ಲಿ ಶಾಂತಿ ಸುವ್ಯವಸ್ಥೆಯನ್ನು ಮೂಡಿಸುವಂಥ ಸ್ವಂತ ಜವಾಬ್ದಾರಿಯನ್ನು ತೆಗೆದುಕೊಳ್ಳುವಂಥ ಇನ್ನೂ ಒಂದು ದೊಡ್ಡ ಸಂಖ್ಯೆ ನಮ್ಮಲ್ಲಿದೆ ಅಂತ ನಿಮ್ಮನ್ನು ನೋಡಿದಾಗ ನನಗೆ ಅನ್ನಿಸ್ತಾ ಇದೆ. ಸುಲಭವಿಲ್ಲ, ಜಸ್ಟಿಸ್ಸಾಗಿ ಕೆಲಸ ಮಾಡೋದು ಸುಲಭವಲ್ಲ. ಯು ವಿಲ್ ಹ್ಯಾವ್ ಲಾಟ್ ಆಫ್ ರೆಸ್ಪೆಕ್ಟ್ ಬಟ್ ವೆರಿ ಲಿಟಲ್ ಫ್ರೀಡಮ್. ನಿಮ್ಗೆ ಸಿಟ್ಟು ಬಂದರೂ ಕೂಡ ಬಯೋಕ್ಕಾಗಲ್ಲ, ಯಾವುದಾದ್ರೂ ಜೋಕ್ ಇದ್ದರೂ ಕೂಡ ನಗೋಕ್ಕಾಗಲ್ಲ. ಬಟ್ ಭಾಳ ರೆಸ್ಪೆಕ್ಟ್ ಇದೆ. ನಿಮ್ಗೊಮ್ಮೆ ಮನಸ್ತಿರ್ಬೋದು, ರೆಸ್ಪೆಕ್ಟ್ ನಾವೇನು ಮಾಡೋದು ಅಂತ. But that's how it is. The respect is given for the honest and sincerity, the characters which are in the uppermost for any human being. And these characters are to be implemented in your daily work. That's the most difficult job. A man can be honest and sincere sometimes. But for a judicial officer, you have to be honest and sincere all the while. You have to keep that guard. And that brings in a lot of pressure. I'm just putting myself in your place. Correct me if I'm wrong, or pass a judgment. But you have taken it on yourself, and you are continuing to do that. And I appreciate your endurance to keep the quality of thinking, quality of delivery, quality of leading the life. It is much easier than said, but Indian judiciary has maintained it right from pre-independence day. I'm really proud, and you should be proud that you belong to such a legacy of Indian judiciary, which is now worldwide recognized. There are different judicial systems in the world. In Western countries, the system is totally different. In Far East, it is different. In Middle East, it is different. European countries, it is different. I don't want to elaborate on that. But our independent Indian judiciary system is a complete in a sense that the methodology which has been adopted through our constitution and the independence of judiciary, executive and legislature, which is paramount important for a successful democracy. Even one among these three is weak, it creates a lot of chaos. And of course, the fourth pillar is always there, like a godfather to look upon. Because of these systems which we have, there are a lot of checks and balances. Adrinda, Anige, the future of this country, I feel, in spite of lot of social appeals we are going through right from 75 years, right from partition of this country, still the future of this country is very safe because of the Indian judiciary. The future of democracy is also very safe because of judiciary. But if we look into the societal justice, societal justice is very, very important. Societal justice will lead to different dimensions in the judiciary. If a society doesn't recognize the goodness among the people, if doesn't honor the honesty in the society, if it is not, the person who is sincere is not rewarded, then the society is not doing its job. Therefore, that leads to a lot of confusion in the value system of our life. And value system is a basis for every action of a human being. What is right to somebody, if it is wrong to somebody, then he will not just believe it. He will not concede it. Therefore, confrontation begins. So a right kind of value system in the society has to be created. Otherwise, all the responsibility will come on judiciary, and judiciary, you know, it can deliver case by case, but it can't deliver the value systems in the real sense. So value systems should come through the practices in the society. Now, if the society has become docile to this, and if society recognizes wrong things, then the judiciary system has to be punishment oriented. It is very, very important to know that any judiciary system should try to be as rewarding as possible than the punishment oriented. But however, our society throws up such a things that punishment becomes inevitable. So there is a lot of always a confrontation between reward-oriented value system, which will create much crime, much less crime, and much less disharmony in the society. So why I have been telling all this is that the time has come now that judiciary should also guide the societal justice, the societal values. The justice has to be done to a person who doesn't have any means to cry. The last man who doesn't have the capacity to cry. So imagine a man doesn't have capacity to cry. Crying is also a strength. But if a person loses a capacity to cry, then we are in a very, very pathetic condition. So all our efforts, right from my role as executive, as a legislature, we had to perform for a societal justice. We give a lot of cases to you through our legislation because of ambiguity in the law. Our endeavor should be, and I've been telling all my colleagues and all my executives also, that whenever we frame a law, whenever we frame a legislation, there should be no ambiguity in this, no scope of ambiguity. The object should be clear, the method should be clear, the law should be clear, and the purpose which the object is there has to be ultimately achieved without any kind of confusion. The ambiguity leads to disputes, and dispute will come to your doorsteps. Therefore, these are the fundamentals which I wanted to share it with you. Now, regarding the technology, digitalization in the judiciary, it is utmost necessary and it is need of the hour. When the things change in the society, that will be reflected into judiciary, as I said earlier. See, there is a lot of confusion between civilization and culture. Civilization, somebody has said very interestingly, they have said that what we have is a civilization and what we are is the culture. Civilization is a growth of needs of the human being. We had a cycle, now we have got a car, scooter, aeroplanes. Similarly, in all the fields. In house, we have got mixies now. Earlier, in Kannada, they used to call bicycle. Bicycle jotege bicycle ಹಾಡಿದ್ದು ತವರು ಮನೆ ನೆನೆಸ್ಕೊಂಡು ಹಾಡು ಹಾಡ್ತಿದ್ರು, ಜೋಳ ಅಕ್ಕಿ ಎಲ್ಲ ಬೀಸ್ತಿದ್ರು. ಆ ಬಿಸಿಕಲ್ ಜೊತೆಗೆ ಹಾಡು ಹೋಗಿದೆ, ಕಲ್ಚರ್ ಹೋಗಿದೆ, ಈಗೆಲ್ಲ ಟರ್ ಅನ್ನಂತ ಮಿಕ್ಸಿ ಮಾತ್ರ ಇದೆ. So, civilization has grown. The culture has to be built up. what we are should be defined. So when we do the digitalization in the judiciary, which is at most necessary, we should see that human component is always there in the inbuilt system of digitalization. We have got e-filing, video conference, lot of digitalization is happening place. That's really good. It is really improved the speed of the judiciary, and it has burdened the less on the staff of the judiciary. At the same time, we have to see that a human element is always alive in the whole system what we create. In 90s, we had globalization, privatization, liberalization. In Kannada, they say, ಖಾಸಗೀಕರಣ ಉದಾರೀಕರಣ ಜಾಗತೀಕರಣ. ಈ ಮೂರು ಜಾಗತೀಕರಣ ಉದಾರೀಕರಣ ಖಾಸಗೀಕರಣದ ಜೊತೆಗೆ ಅಂತಃಕರಣವನ್ನು ಮರಿತಾ ಇದ್ದೇವೆ. ಅಂತಃಕರಣ ಅನ್ನುವಂಥದ್ದನ್ನು ಇಟ್ಟುಕೊಂಡು ನಾವು ಮಾಡಿದರೆ ಭಾಳ ಆಗ್ತದೆ. ಈ ಡಿಜಿಟಲೈಸೇಷನನ್ನು ಸದುಪಯೋಗ ಮಾಡ್ಕೋಬೇಕು. ಆರ್ಟಿಫಿಷಿಯಲ್ ಇಂಟೆಲಿಜೆನ್ಸ್ ವಿಲ್ ಸರ್ಟನ್ಲಿ ಹೆಲ್ಪ್ in building up your logic in your justice, but ultimately the decision to give justice in particular case should be on the rightness and consciousness of a judicial officer. That is very much essential, and I am proud that Indian judiciary has kept it conscious right above everybody, and we are already proud of it. And we have Justice Chandrachud and Bopanna here. They have been a very, very seasoned justice, and they have gone through so much of judicial activity, and they have handled different circumstances which are totally unpredicted in their lifetime, and it came from different states. They have been very upright, and they have not only delivered justice, they have delivered human justice to a lot of people. Therefore, I am really happy that they are gracing this occasion, and let all the judicial officers be benefited through their experience and their thoughts. And our own Nagaratna madam is here. I was just talking to her. I said, Madam, you are going to be the first woman Chief Justice of India. She said, I don't know. Then I said, we know that you are going to become. But she was very quick to retort that I have to put a lot of hard work, sincere hard work. That's what she is, and we are proud of her. And our Chief Justice has brought a new dimension for Karnataka High Court through his, not only justice, through his thoughts. And the deliverance is really solved a lot of our problems. See, it's so, we have to work together. That is one way of thinking. The other way of thinking is, without us, you don't have job. So we create a lot of cases for you. But that's how it is. We are independent, but at the bottom of the line, to give justice to the society, we are also interdependent. And let us all put all our heads together and all our efforts, sincere efforts, to give justice to not only who seek, you have to give justice those who doesn't seek, but they need this justice. And the person, you should give justice for the person who even can't cry. That last person should also get justice. And Karnataka legacy, judicial legacy, is one of the top legal legacy which we have, and we have to keep this legacy flying high, and let's strive everybody for that, and let this society be a rewarding society rather than the punishment society. Let's hope. It's a very ideal situation, I know that. It's very difficult, but nothing, we don't lose anything by hoping for the best. Thank you, sir.
the Honorable Chief Minister of Karnataka has lauded the efforts of the judicial officers towards imparting justice. And of course, the Indian judicial system is one of the best in the world, and the Honorable Chief Minister has hoped that the judiciary would continue to lead from the front towards imparting harmony and peace in the society. Let's all once again give a huge round of applause to the Honorable Chief Minister. Sanmanya Mukhyamantриಗಳಿಗೆ ಧನ್ಯವಾದಗಳು.
Ladies and gentlemen,
ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಕಾರ್ಯನಿಮಿತ್ತ ತೆರಳುತ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೊಮ್ಮೆ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
ಧನ್ಯವಾದಗಳನ್ನು ಸಮರ್ಪಿಸುತ್ತೇವೆ. Ladies and gentlemen, Benjamin Disraeli once said, "Justice is truth in action." As Chief Justice of High Court of Karnataka, Honorable Shri Justice Rituraj Avasthi is in the forefront of that action. May I now respectfully request Honorable Shri Justice Rituraj Avasthi, Chief Justice High Court of Karnataka, for his presidential address. Sir, please.
ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ Honorable Shri Justice Rituraj Avasthi.
My Lord, Honorable Dr. Justice Dhananjay Y. Chanchud, Judge Supreme Court of India and Chairperson E Committee, Supreme Court of India, Shri Basavaraj Bommai, Honorable Chief Minister of Karnataka, Honorable Shri Justice A.S. Bopanna, Judge Supreme Court of India, Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, my sisters and brother judges, Shri Malagonda, President and other office bearers of Karnataka State Judicial Officers Association, learned judicial officers, members of print and electronic media, distinguished guests, ladies and gentlemen. Yalaregu Namaskara. Good morning to all of you. At the very outset, I take this opportunity to express my heartfelt thanks to Honorable Dr. Justice Dhananjay Y. Chanchud for having graced the occasion by inaugurating the 20th Biennial State-Level Conference of Judicial Officers. In spite of his busy schedule, he has consented to inaugurate this function. We are grateful to His Lordship. Any number of words and praises cannot do justice and efficiently summarize the contribution of His Lordship to the legal jurisprudence of our country. His Lordship's judgments not only make a great academic reading for our entire legal community across the country, including young students, teachers, and members of the bar and bench alike, but also shape the law of the land, upholding the Constitution and its values in the truest spirit. His Lordship has brought about a revolution in the matter of introduction of citizen-centric services and host of digital reforms, making judiciary accessible to all sections of society. Under the leadership of His Lordship, the E-Committee has taken the first step of introduction of artificial intelligence in the judicial domain by developing Supreme Court Vidhik Anuvad software, short term as SUVAS, which is a machine-assisted translation tool trained by artificial intelligence and has the capacity and capability of translating judgments and orders from English into 9 vernacular languages and vice versa. His Lordship has also been monitoring the availability of infrastructure to the district judiciary. Information technology-related infrastructure like servers, computers, printers, scanners, LAN, etc. have been provided to all the courts in the districts and talukas. Infrastructures to establish e-Seva, VC cabin, help desk counter have also been provided to help the advocates and public to avail e-court services. The E-Committee played a crucial role under His Lordship in bringing the fundamental rights to access justice, especially during the COVID-19 pandemic, and made India a global leader in conducting cases through video conferencing. It is due to the hard work under His Lordship's leadership and vision that the E-Committee of the Supreme Court of India was awarded the Platinum Award for excellence in digital governance for the year 2020 by the Honorable President of India. May I also share that I have the privilege of having a special connect with Honorable Dr. Justice Chanchud. His Lordship was my Chief Justice at Allahabad High Court. I had the privilege and honor to share the bench with His Lordship during His Lordship sitting at Lucknow bench as Chief Justice. I learned many of things on judicial and administrative side from His Lordship. It is my fortune to have an opportunity to share the dais today with him. I and the entire Karnataka judiciary wholeheartedly welcome His Lordship to this function. We are also grateful to the Chief Minister of Karnataka, Shri Basavaraj Bommai, who is the guest of honor today. He has been always very cooperative and willing to provide necessary infrastructure to the state judiciary. Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, who was supposed to come to this conference, could not attend today due to unavoidable circumstances. His Lordship has requested me to convey his best wishes for the grand success of the event with meaningful deliberations. We are all fortunate and happy to have amongst us Honorable Mr. Justice A.S. Bopanna, Judge Supreme Court of India, who is the son of the soil and who has adorned the high post of Judge of Supreme Court. His Lordship is known for his simplicity and friendly attitude. We are grateful for his presence today. We are also fortunate and happy to have amongst us Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, the proud daughter of Karnataka State. Lordship has broken many records and is the first women judge from Karnataka to be elevated to the apex court. I thank Honorable Mr. Justice Bopanna and Honorable Srimati Justice Nagaratna for taking out precious time from their busy schedule and honoring us with their gracious presence. I may say that their Lordships have made the entire legal fraternity of Karnataka extremely proud, and their immense contribution to our court continues to guide all of us daily in our work. I and the entire Karnataka judiciary heartedly welcome their Lordship to this function. Conference of this type is a good platform to discuss topics that concern day-to-day functioning of the trial courts and to throw light on various aspects that would enhance the efficacy of justice delivery system. The theme of the conference, Digitalized and Modern Judiciary for Effective and Timely Justice, has been very aptly chosen for this conference. Digital technology has been transforming the legal landscape in our country. It is entering almost all facets of human activity with great space. The virtual courts, online courts, and online dispute resolution have come to stay. The COVID-19 pandemic affects human lives and affected the functioning of judiciary. It has amplified the need to strengthen the digital capabilities of the judiciary and has provided an unprecedented opportunity for change. The Supreme Court E-Committee, under the leadership of Honorable Dr. Justice D.Y. Chanchur, has been undertaking various initiatives to digitally transform judicial infrastructure, processes, and procedures. His Lordship has always emphasized about the reliance on technology in order to enhance access to justice. The High Court of Karnataka has been taking proactive initiatives from time to time to digitally transform judicial infrastructure, processes, and practices. As a result, the High Court of Karnataka was selected along with few other high courts for implementing the pilot digitization project. I express my gratitude to His Lordship for selecting the High Court of Karnataka for the said project. The judicial officers in Karnataka are rendering services in the administration of justice by working hard and sincerely. However, backlog of cases is burdening the judiciary. Technology can act as a catalyst for simplifying processes and make justice accessible and affordable to a large section of the population. It has become inevitable for the judicial officers to keep pace with developing modern technology. New times demand new measures. In this regard, the theme selected for this conference is very apt, and the subjects selected for deliberations are very useful. This session 1 is regarding advanced technology for justice delivery, its applicability and challenges ahead. The session 3 is regarding role of judiciary in a changing world. Session 4 is regarding appreciation of electronic evidence. These sessions 1, 3, and 4 would be very useful in equipping you, the judicial officers, with the advanced technology which will help you in rendering effective, timely justice. These sessions could be made more productive by your active participation in the deliberation. There are one more interesting subject selected for deliberation for session 2, lifestyle diseases, a silent killer, and personality and development and capacity building. Maintaining good health is absolutely necessary for a judicial officer. Unless an officer has good health, he or she cannot function effectively. The nature of work of a judge requires him to be seated for several hours together and thereby inviting several work-related ailments. In this regard, session 2 would be very useful. So far as personality and conduct of a judicial officer is concerned, one thing which should be borne in mind is that a judicial officer should never compromise his judicial independence. It is true that he has to interact with concerned stakeholders while implementing the provisions of Legal Services Authorities Act. However, he should know the distinction between his judicial work and his legal service role. Judicial independence does not mean that one can do whatever he likes. The Honorable Supreme Court in Union of India versus Madras Bar Association, 2010, volume 11, page 1, has held, and I quote, "Independence is not the freedom of judges to do what they like. It is the independence of judicial thought. It is the freedom from interference and pressures which provide the judicial atmosphere where he can work with absolute commitment to the cause of justice and constitutional values. It is also the discipline in life, habits, and outlook that enable a judge to be impartial," unquote. Therefore, the judicial officers, while maintaining judicial independence, should also maintain discipline in life, develop good habit and outlook. The Constitution of India uses the expression subordinate judiciary to describe judges of the district judiciary. However, it does not mean servitude. It only refers to the position of being in a hierarchically lower position as compared to some in a higher position. Merely invoking our achievements and accomplishments will not be sufficient. We will have to aim for greater glory, and this conference should be a source of inspiration. We all are eagerly looking forward to hear the words of wisdom from the dignitaries on the dais. I thank the organizers for this function for giving me this opportunity to preside over and express my thoughts in this inaugural session. I wish conference a grand success. Thank you. Jai Hind.
Well, ladies and gentlemen, the Chief Justice of High Court of Karnataka has called upon the judicial officers to take care of their health and also to utilize the technology in the highest order to impart justice very, very quickly. Let's all once again express our gratitude to the Chief Justice High Court of Karnataka, Honorable Shri Justice Rituraj Avasthi. Thank you very much, sir.
Ladies and gentlemen, Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, has always been a source of motivation for us. It's my pleasure to request Honorable Justice Srimati B.V. Nagaratna, Judge Supreme Court of India, to address this august gathering. Madam, please.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Honorable Dr. Dhananjay Yashwant Chandrachud, Judge Supreme Court of India, who has inaugurated this conference. Honorable Chief Minister of Karnataka, Sri Basavaraj Bommai, Guest of Honor. Honorable Justice Sri A.S. Bopanna, Judge Supreme Court of India, who has graced the occasion. Honorable Sri Rituraj Avasti, Chief Justice, High Court of Karnataka, who is presiding over this function. My dear brother and sister judges of the High Court of Karnataka, former judges of the High Court of Karnataka who are present here today, learned Registrar General and Registrars of the High Court, Sri Malan Gaud, President, and Sri Jayaprakash, General Secretary, and all other office bearers of the Karnataka State Judicial Officers Association, my dear judicial officers of the District Judiciary of Karnataka, distinguished invitees and guests, members of the press and electronic media, ladies and gentlemen. A very good morning and warm greetings to all gathered here. I, at the outset, congratulate the President and office bearers of the Karnataka State Judicial Officers Association for organizing the 20th Biennial State-Level Conference of Judicial Officers on the theme, Digitalized and Modern Judiciary for Effective and Timely Justice. I am elated and happy to be here this morning as we all acknowledge the role of the district judiciary in enabling citizens access to justice and reinforce the need to continue to strive towards ensuring qualitative, responsive, and timely justice to them. I am also happy to be here to have been invited to address, I think, one of the best district judiciaries in the country. Making access to justice a reality is, in my opinion, one of the most laudable objects of the Constitution. Access to courts is an essential component of access to justice. This includes enabling litigants to overcome barriers to getting into court, ensuring that appropriate treatment is meted out within the court system, which would in turn ensure that litigants obtain the outcomes from the legal system. Given that a court, whether a sub-court or a taluka court in a district or the Supreme Court of India, is sacrosanct, the integrity and sanctity of all these institutions is to be maintained by all of us and has to be visibly demonstrated in the manner in which justice is dispensed. It is therefore imperative that members of the judiciary, be it the higher judiciary or the district judiciary, cultivate in their functioning what I have always been stressing in the Karnataka Judicial Academy as the 4 Ps, namely punctuality, probity, promptness, and perseverance. Another dimension on the discourse of access of justice is timely justice, which is potentially the next frontier to achieve economic growth in our country. Access to justice is therefore to be understood both in terms of salutary effects it could have on society as well as the economy. It is well accepted that the economic growth of a nation is closely linked to the ability of the courts to enforce contracts and resolve disputes, particularly those having commercial and financial implications. Ease of accessing courts and securing timely justice and certainty of justice are a few of the primary yardsticks to measure ease of doing business in a country like ours. It is also relevant to note that the district judiciary plays a very significant role in corporate and commercial litigation. For instance, suits for injunctions in matters concerning infringement of protected intellectual property, suits for breach of contract, and an appeal from an arbitral award lie before the district courts. To put the problem of slow or uncertain enforcement of contracts and contractual obligations in perspective, we need to be mindful and understand of the fact that the slow enforcement encourages bad borrowing conduct, which in turn may detrimentally impact markets. The consequence is that there may be immense potential for entering into beneficial contracts, but they are not entered into because of the perceived tardy nature of the judicial mechanism. While the bulk of the efforts and resources to improve ease of doing business has been targeted towards empowering the tax and company law tribunals and the higher judiciary, it is my view that investing resources, both manpower and infrastructure, and efforts towards empowering the district judiciary to act in a timely manner would significantly help enhance ease of doing business and in turn aid in economic development of our country. Coming to the theme of the conference, closely linked with the objects of securing access to justice is the idea of digitalization of courts in India. Digitalization has been viewed as a tool for inclusive justice. Access to justice, in my opinion, necessarily includes knowledge of the outcome of litigation at every stage. Virtual hearings and digital status reports have enabled litigants to be constantly updated with the status of litigation. Digitalization and modernization have played a key role in enhancing the availability of research tools to judges. For example, ascertaining the current position of the law on a particular aspect, determining whether a given position of law has been subsequently overruled or affirmed by the same court or a higher court, have been made easy and effortless because of the digitalized research tools available presently. And I can assure Justice D.Y. Chandrachud that in Karnataka, our judicial officers are really modern in that sense. In fact, Dr. Justice Chandrachud has elaborated on this idea in his dissenting opinion in Shantini versus Vijaya Venkatesh, wherein he very aptly observed that adjournments and delays in justice delivery, owing to factors such as lack of availability of travel time or resources, can easily be resolved and addressed by conducting virtual hearings. We have all been seeing the onslaught of the pandemic in the last 2 years. The COVID-19 pandemic has necessitated the need for virtual hearings, which in turn requires upgradation of digital infrastructure. The system of virtual hearing, I think, has come to stay. Even if not entirely a substitute to physical hearing by courts, virtual hearings may be resorted to when parties, witnesses, or advocates cite various difficulties in appearing on a specified date at a specified city or in traveling for the purpose of litigation. Moreover, when parties reside abroad, they could appear before the courts through the virtual hearing model. However, it is my personal view that one has to bear in mind that automation and logistic support offered by a digitalized legal system cannot be construed to be a substitute to the application of mind by the judges entrusted with the adjudication of cases. That having been said, it continues to hold true that the district judiciary is the face of the Indian judiciary, inasmuch as the common man is concerned. It is in that context I once again emphasize that the district judiciary is the bedrock of our legal system, and as it is positioned at a primary level in the hierarchy of courts. I have always told our officers in the Karnataka Judicial Academy when they came for training that the district judiciary is like the long backbone of a human anatomy. And if our entire judiciary is to be standing upright, then the backbone must be straight and upright. The onus is on every judge and officer of a court at every level in the hierarchy to ensure that justice delivery system does not crack from within, resulting in the failure of public confidence in the system. It is significant to note that nearly 90% of the pending cases in India are before the district courts and courts subordinate thereto, which are the first ports of call for most legal disputes. The pendency of cases in all levels of the judiciary rose significantly during the COVID-19 pandemic, when most courts functioned virtually and in a truncated schedule. This situation necessitated ramping up of digital infrastructure at all levels of the judiciary. Notwithstanding such efforts, the impact of the pandemic on the backlog of cases is quite alarming. When statistical data concerning the district judiciary in Karnataka alone is studied, it would reveal that the pendency of cases in the civil and criminal courts of the district judiciary of the state increased by over 250,000 from between the period December 2019 and December 2021. The pendency of cases is attributable only to diminished disposal rates during the said years and, of course, owing to the pandemic. Taken together, it is undeniable that the pandemic has had a significant impact on the pendency of cases. What this situation calls for at this juncture is to upgrade and accelerate the manner in which cases are heard and disposed. I am sure this conference would deliberate on this vital aspect. Digital tools can contribute in this area too. For instance, digital tools could be employed which would automatically prescribe definite timelines for each case based on a multitude of factors such as nature of the matter, date of institution, stage of the trial, number of witnesses to be examined, etc. Such a system would naturally have a favorable impact on the practice of seeking and granting adjournments because of the intense monitoring practices that are in place. I recognize that judges of the district judiciary have enormous responsibilities, both on the judicial and administrative side, and they are required to discharge such responsibilities effectively in making courts more responsive to the litigant public. Therefore, I appeal to the district judiciary and its officers to take a more proactive role in galvanizing their respective units. In this regard, I would like to refer to one of the fundamental duties enumerated in Article 51A(j) of our Constitution, which requires all citizens to strive towards excellence in all spheres of individual and collective activity so that the nation rises to higher levels of endeavor and achievement. I emphasize that members of the judiciary must, in the spirit of Article 51A(j), respect their professional obligations and prove to be leaders in providing qualitative, responsive, and timely justice. Having regard to the fact that district judiciary is the bedrock and the backbone of the Indian judicial system, the pre-service training imparted to the learned members of the district judiciary must be holistic so as to accommodate and assimilate the best elements of subject knowledge, practical ability to administer justice by implementing subject knowledge, and ability to adapt to the dynamic legal environment. Further attempts must be made to train the members of the district judiciary in involving themes and areas of commercial litigation, intellectual property law, and arbitration. At the same time, I must say that the High Court must ensure that not only timely recruitment, but timely promotions are made for the judges so that their morale is always kept high. As a parting note, if I may also add that by the end of this year, we will have a Chief Justice of India in Honorable Dr. Justice D.Y. Chandrachud, whose proactive and work ethic, diligence, dedication, and fairness, apart from his humility, will serve as a benchmark for each one of us. The onus is on us all to strive to achieve and emulate the standards that Justice Chandrachud has and will set for all of us. I hope we do not fail in our ongoing commitment to ensure that the nation's need for justice is fulfilled fairly and honorably. I would end by quoting from S.P. Gupta versus Union of India, AAR 1982 Supreme Court on the life of a judge. And I quote, that the life of a judge does not call for great acts of sacrifices, but it does call for small acts of self-denial almost every day. With this, I once again thank the organizers of this conference for inviting me to Bangalore. I haven't come to Bangalore since January, and this is an opportunity not only to come to my hometown, but also to visit, be present in this conference, which is a very important conference for all of us and also for each one of you. And I also thank each one of you for your kind attention. Namaskar.
Honorable Srimati Justice B.V. Nagaratna indicated digitalization and modernization are the research tools to judges and thus emphasized it is the need of the hour. Thank you, ma'am. Thank you for your inspiring words.
We now request Honorable Shri Justice A.S. Popanna, Judge Supreme Court of India, for his address. Bandhugale swagatisi Honorable Shri Justice A.S. Popanna.
Honorable Dr. Justice D.Y. Chandrachud, Judge Supreme Court of India and Chairperson E-Committee, Supreme Court of India. Sir, with your permission, we have been introduced as son and daughter of Karnataka. Maybe I think I can call you son-in-law of Karnataka. Honorable Justice B.V. Nagaratna, Judge Supreme Court of India. Honorable Justice Rituraj Avasthi, Chief Justice, High Court of Karnataka, Mr. Malangaud, Mr. Jaiprakash, and all other office bearers of the association, sister and brother judges from the Karnataka High Court, former Lokayukta and the former judges from High Court of Karnataka were all my colleagues, Registrar General and all the other registrars of the High Court of Karnataka, my dear judicial officers, invitees, ladies and gentlemen, a warm greeting to all of you. It is heartening to note that the Judicial Officers Association has chosen the subject, digitalized and modern judiciary for effective and timely justice, as the theme for its 20th Biennial State Level Conference. Having Honorable Dr. Justice Chandrachud to inaugurate a conference with this theme is like the icing on the cake because of the passion the Honorable Judge has for this subject. From the time when Supreme Court had interpreted the meaning of the word presence in a wider sense in the case of Praful Desai in the year 2003, to hold that the evidence recorded by way of video conferencing to be evidence recorded in the presence of the accused and will meet the requirement of Section 273 of CRPC, while describing video conference as actual reality and not virtual reality, we have traveled a long way. In fact, the computerization of courts was also started as far back as in the year 2005. But the watershed period has been the last couple of years when it has transcended all barriers. It is said, necessity is the mother of invention. So far as digitalization of court proceedings are concerned, this is exactly what has happened. Usually, the virus affects the digital system and corrupts the system. Hence, you always install antivirus software to prevent. But the novel coronavirus, though had played havoc with the human lives, it has turned out to be a friendly virus in accelerating the digitalization of courts. The process of digitalization of courts, which was achieved in the last 2 years, if not for the pandemic, which brought about a circumstance to accelerate, would, in my estimate, have taken at least a decade, because at every step we would have weighed the option, considered the pros and cons, cost involved, and shelved the project to take a decision on another day. But the virus did not allow this to happen. This is not limited to our country alone. All of us assume that the Western world is more advanced in digitalization of court proceedings, but it is not so, and it is the pandemic which had its role even there. I was reading a report of the PEW Charitable Trusts of the United States of America, wherein it had said about how courts in America embraced technology, met the pandemic challenge, and revolutionized their operations. The report says the civil court's adoption of technology in USA was unprecedented in pace and scale during the pandemic. Even in Texas system, which had never held a civil hearing via video before pandemic, conducted 1.1 million remote proceedings between March 2020 and February 21. Courts in Michigan held more than 35,000 video hearings between 1st April to 1st June, as compared to no such video hearings during the same period in 2019. I do not know whether such statistics with specification is available, but certainly I am sure our progress has also been many folds. Technology has the potential to substantially improve the legal system. Digital tools helped the courts during the health emergency, and Justice Chandrachud accelerated it. For all this to become a permanent feature with all the safeguards, feedback of the actual working would be necessary. All you learned judges who are at the helm in the trial court and had the hands-on experience can provide such feedback, and this conference will be a great opportunity to voice your suggestion in the various sessions over the 2 days. The organizers of this conference have adopted the most appropriate theme at the right time. I am sure this conference will come out with a whole lot of ideas for adoption of digital mode in our regular court proceedings, which would be litigant as well as advocate friendly and will help in accelerating the judicial process. I wish the conference will be fruitful and will be helpful in achieving the desired result. I thank the Chief Justice of Karnataka High Court and the Karnataka State Judicial Officers Association for providing me an opportunity to be a part of this program. Thank you one and all. Jai Hind, Jai Karnataka.
ಡಿಜಿಟಲೈಸೇಷನ್ನ ಸಂಪೂರ್ಣ ಮಾಹಿತಿಯನ್ನು ಅಂಕಿಅಂಶಗಳೊಂದಿಗೆ ಸಭೆಯೊಂದಿಗೆ ಹಂಚಿಕೊಂಡಂತಹ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತಹ ಶ್ರೀಯುತ ಎಸ್ ಬೋಪಣ್ಣ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು ಸರ್.
Well, ladies and gentlemen, it's now time for the inaugural address. It's our privilege and pleasure to request Honorable Dr. Justice Dhananjaya Y. Chandrachud, Judge Supreme Court of India and Chairman E-Committee, Supreme Court of India, for the inaugural address. ಬಂಧುಗಳೇ ಸ್ವಾಗತಿಸಿ Honorable Dr. Justice Dhananjaya Y. Chandrachud.
Namaskar. My very distinguished colleagues on the bench of the Supreme Court, Justice A.S. Bopanna, Sister Justice B.V. Nagaratna, with whom I go a long way since we were in college and school in Delhi at the same time. Our fathers were distinguished members of the bench at the same time of the Supreme Court. Justice Rituraj Avasthi, Chief Justice of the High Court, Honorable Judges of the High Court, Honorable members of the District Judiciary. I prefer to call it the District Judiciary and not the subordinate judiciary. All the members of the Karnataka State Judicial Officers Association, including those who are present on the dais, and all of you in the audience. Justice Bopanna called me very aptly the son-in-law of Karnataka, which is really, really true in a way, because my mother-in-law, my father-in-law, and my sisters-in-law settled down in Karnataka, and they have made Karnataka their home. So I'm certainly a son-in-law of Karnataka, at least by naturalization, if not by adoption. I also belong to, I can be called a nephew of Karnataka, because the very noted Kannada playwright Adya Rangacharya, who is known more well known by his pen name of Sriranga, was married to my father's sister, and they lived in Dharwad. And his works in 1950, 1960, 1970, 1980, until he passed away in 1984, they really anticipated the social change which is taking place in our society, the change in gender roles, the advancement of gender, the advancement of marginalized communities. This was foreseen by him 30 years before this took place in our country. His daughter, Shashi Deshpande, who is a highly celebrated English writer, happens to be my first cousin, and her sister, Dr. Usha Desai, who with her husband stays in Mumbai, she a very distinguished doctor in her 80s, she has now taken it upon herself to translate Sriranga's works from Kannada into English so that they can be spread, the message can be spread to the rest of India. I've spent my childhood years driving from Mumbai, Pune, Kolhapur, Belgaum, and then Dharwad, and then spending vacations with the family in Dharwad. So I have warm memories of those early years of childhood. Now, how do you identify a civil judge? I was told this story by Justice Sarosh Kapadia, who became the Chief Justice of India, and then by Justice R.C. Chavan, who is the Vice Chairperson of the E-Committee. Well, at one time, if you wanted to identify a civil judge, you would always identify a civil judge as a person who you would find with a black coat, a white trouser, a tie, and riding a bicycle. It was a little gender biased because it didn't factor in the few members from the women lawyers or women judges who are coming into the profession. And now there are states where almost the same quantum of women judges as men judges joined the district judiciary. So that was how you identified civil judges in the years gone by. I know as a young child, when my father was a judge of the Supreme Court and Justice Nagaratna's father and he were together on the Supreme Court, Justice Nagaratna's father was a very distinguished scholar, not merely of law but of Sanskrit. And as Chief Justice of India, my father had coined a very special phrase for Justice E.S. Venkatramaiah. Fondly, when they met every morning in the Chief Justice's chamber for a cup of coffee, my father would always call to him and say, "Swamiji aiye." So he always called him Swamiji because he was so learned. But how did you identify a Supreme Court at that time? You would see all of them traveling by chair car from Delhi to wherever they lived, whether it was Maharashtra or Bangalore or Chennai or Ernakulam, as Justice K.K. Matthew lived in, or Justice Krishna Iyer. Because the first 400 kilometers in your LTC had to be borne from your own pocket, and the government would give you the rest of the pro rata for the payment of your LTC. They drove their own cars. There was no 200 liters of petrol available. So we used to stay in this place in Mumbai called Malabar Hill, which was in the bottom of the hill. And when we came to the top of the hill, all the three judges who used to carpool with my father would switch off the engine, and then they would tell me, a little child sitting in the back, "Please push the car so that the petrol will run longer." So these were the times which judges really came up. I think the Shetty Commission changed all that. So also the involvement of the Supreme Court in cases such as Malik Mazhar Sultan. So we are much better off today than what our forebears were, our ancestors in the judiciary who've passed on the baton to us were. Today, how do you identify a civil judge? Today, I dare say, you will not be able to identify a civil judge separately from any other citizen because you merge with so many others who are tech-enabled citizens of India. That is the forward vision of the Indian judiciary. Before I actually present a few thoughts which I have coined for this morning, I must tell you about the performance of the Karnataka state judiciary, the district judiciary, in the recent 2 years. Between 24th March 2020, when the pandemic broke out, and 22nd April 2022, 31,09,888 cases were registered. These statistics I don't get because I am a chairperson of the committee. They are now available on the National Judicial Data Grid, which is a transparent system. We are open to all citizens. 28,76,059 cases were disposed of in the district and taluka courts in Karnataka. So when we talk about the flip side, about what ails the judicial system, we must also remind ourselves what is the strong aspect of our system. That during these years of the pandemic, when 31 lakh cases could be registered, it reflects the citizens' confidence. We were able to dispose of 28.76 lakh cases in the district and taluka courts. Today, 1,184 judicial officers use the Justice mobile app, which has been developed for Karnataka in special, and of course for the rest of the country. Virtual courts for traffic challans are operational in Karnataka. Very interesting little tidbit which I can share with you. We have this process delivery mechanism now which we have prepared in the E-Committee called N-Step. N-Step is nothing but a smartphone gadget which records the service of a process or summons and records the GPS coordinates of the house where the process is being delivered. It is signed by the person who accepts the service. If service cannot be delivered, he takes a photograph which is uploaded onto the central server. So 2,25,000 processes were allocated to bailiffs in Karnataka. 2,09,120 deliveries were attempted, and 1,49,343 processes have been delivered through the N-Step mechanism. This shows the involvement of the Karnataka judiciary in technology involvement. 4,13,925 final orders and judgments of the Karnataka High Court are available on the Judgment Search portal today, which is a free text search portal which has been devised by the National Informatics Center in coordination with the E-Committee. But let's not only pat ourselves on the back. There are other statistics which I must always tell you, because we look at both sides of the picture and then form a view. As on 22nd April 2022, 18.37 lakh cases were pending in the district courts in Karnataka, out of which 8.82 lakhs are civil and 9.55 lakh are criminal cases. 157 cases are pending for more than 30 years, 6 of them criminal and 151 civil cases. The oldest criminal case, CC 648 of 2000, registered on 22/1/1985, is pending before the Principal Judge Neelamangala, Bengaluru, but the reason is that the accused is absconding since it was registered. The oldest civil case is Insolvency Case 2 of 1962, registered on 5th January 1962, which is pending before the Principal Judge and Civil Chief Judicial Magistrate at Belgavi. 1,84,133 criminal cases are pending because the accused is absconding. Now, 8,948 cases are pending because trials have been stayed by the High Court. The oldest is of 1978, a petition for final decree 76 of 1978 before the Principal Senior Civil Judge, Mangalore. So these are some of the statistics which I think are important for us to lay bare when you are going to discuss the impact of technology on the judicial process and what role the district judiciary has to play. I'm delighted to have this opportunity to interact with you this morning, and I'm grateful to the learned Chief Justice for even having invited me. The duty of a judge is well served on a robust foundation of experience, not just of one's own, but of the entire judicial fraternity. These conferences are a key to bolstering institutional development and knowledge. In the words of one of the finest jurists of all times, Oliver Wendell Holmes, the law in its own experience, he says, holds true for the institutions that uphold the law. I could not agree more with this statement. Judging has been my life. As a child, I have seen my father dedicate his life to the law. His impeccable sense of duty and dedication served as a constant inspiration in my journey as a judge of the Bombay High Court, at the Allahabad High Court as the Chief Justice, and now at the Supreme Court. 22 years on the bench has taught me a lot about law and life. One of the most significant takeaways in my judicial experience is the systemic importance of the judiciary at the grassroots level. The hierarchy between courts is a matter of administration and not one of importance. It is the responsibility of every member of the judiciary to foster a space that echoes justice. Courts in the district judiciary are the first doorway to a responsive court system. It is sometimes said that there is a divide between judges who are drawn from the bar and judges who are drawn from the service. In many high courts, the divide is more pronounced than the others. Speaking of myself, I must tell you that some of the greatest experiences of life that I have learned as a judge since 29th of March 2000 are the experiences I have imbibed from judges who came from the district judiciary, whether in my contact with them as a lawyer appearing for the High Court, when I spoke to the Registrar Vigilance or the Registrar Legal, or as a judge when we interacted with our own colleagues who came from the district judiciary, who told us about the problems which the district judiciary faces, the realistic assessment of the conditions in which way they work, what transfers mean to a district judge if those transfers are not made with the highest element of transparency and probity by the high courts. How spouses would be separated in Uttar Pradesh, for instance, where one spouse had to constantly remain in one station while the other spouse would be posted all over, only in the interest of the education of the children. So these lessons of life, without which my training as a judge would be incomplete, I learned from my interaction with the district judiciary in India, in different states. Thus, in my address today, I wish to focus on the most critical cog of our judicial system, the district courts. I will be addressing the infrastructural changes that can be implemented at the district courts and the high courts to achieve substantive and procedural justice. However, before we even speak of procedural or substantive justice, it is imperative that our courts are accessible as institutions. Accessibility, in one sense, is emblematic of justice. The digitization of courts is one way in ensuring greater convenience and reducing costs associated with litigation. The digitized world that we presently inhabit is unimaginable from a few years ago. It has reconfigured our sense of self and community by adding another dimension to our lives, that of digital personhood. It has also transformed our conception of basic services. The Digital India program aims to achieve inclusive growth by transforming India into a digitally empowered society and knowledge economy. The union and the state governments are constantly creating initiatives to improve governance, provide public services, and strengthen accountability mechanism. In this rapidly changing milieu, the judiciary cannot be far behind. Judicial infrastructure has to necessarily adapt to the digital world. The silver lining to the havoc wreaked by the pandemic was that it presented the judiciary with two choices. Either we adapt to a virtual system or aggravate the problem of pendency that plagues our system. In 2004, the Supreme Court of India established the E-Committee to adapt the administrative reforms in the judiciary to the information technology revolution. The main aim of the E-Courts project was to provide a transparent, accessible, and cost-effective justice delivery system to all citizens through information and communications technology and internet-enabled courts. Since the pandemic struck, the e-Tal website has recorded over 3.54 billion electronic transactions under the E-Courts project. A total of 9.6 million cases were heard by all courts through video conferencing. The e-filing software has been utilized to file over 1,100 cases. Finally, as a testament to the effectiveness to this mode of justice delivery, out of 13 million cases registered in India, 8.3 million cases were disposed of, thus achieving a disposal rate of over 60%. To ensure sustainable progress that is cognizant of the digital divide, the e-Seva Kendras assisted litigants with obtaining soft copies of judicial orders, e-filing of petitions, appending digital signatures, facilitating e-payments, and guiding people on availing free legal services from legal aid authorities. In other words, technology for us is not intended to reach out only to the high-value commercial disputes or make the Indian judiciary responsible to the needs of investment and industry. Technology for us is to reach out to the doorstep of every citizen. And one of our latest initiatives in the E-Committee is to merge the e-courts project and the delivery of e-court services with the common service kendras, the common service centers, so that every village will be entitled to avail of all the e-court services which are provided otherwise in the district judiciary and in the high courts. As a result of the virtual performance of our judiciary and the virtual hearing platforms, I believe the Supreme Court of India became truly a national court. We became a truly national court in a participative sense, not even a sovereign sense. We were always a national court since the day we were established. But we have become a national participatory court, where young lawyers from across the country, be it Bangalore, be it Kerala, be it Tamil Nadu, be it Manipur, Maharashtra, just name the state, Bihar, UP, they address you. They have the safety of their own homes. Young women lawyers are able to come and address cases to the Supreme Court, consistent with their needs of multifarious responsibilities which all women have to perform in our society. So technology does not just change the mode of adjudication, but it also transforms the adjudicatory process itself. Hence, phase 3 of the e-courts project places the e-judiciary at a central part of its vision. If strategically deployed, this can completely transform the citizen's experience for the judicial process. For instance, the traffic courts dealing with ordinary traffic violations have received a substantial boost with the introduction of automated settlement processes, which allow persons to pay their dues without grappling with litigation and without having to deal with touts in our courts. Similarly, several avenues for introducing artificial intelligence in the dispensation of justice are being explored, such as marking defective petitions and projecting case progress. Digitization is actively pursued through the National Judicial Data Grid, with the hope that it eventually helps with smart scheduling of cases, auditing disposal rates of high courts and other courts, and identifying the specific causes of delay. In the first session on application of advanced technology, I invite all of you to expend some thoughts on how this transition can be made in a just and effective manner. Integrating our pre-existing systems with technology is the future of our justice system. The rights of all stakeholders could be well preserved by critical inputs from judicial officers. I must commend all the courts in the state of Karnataka for demonstrating a progressive commitment to the e-courts initiative. Karnataka was one of the first states in the country to use the virtual forum to hear cases on a regular basis. This is a huge step towards the state's target of ensuring zero pendency of cases older than 5 years. The staggering figures on the penetration of e-court services, e-Seva Kendras, e-filings, and live telecast of High Court proceedings sets Karnataka apart as a pioneer in justice delivery. I implore all of you to continue on this path and deliberate on best practices across our respective courtrooms. I believe that these initiatives will bolster Karnataka's image as a litigant-friendly and cosmopolitan state. Yet, as we are now going to start live streaming your cases, please understand that it changes the role of each one of you, whether you are in the high courts or in the district judiciary. Every judge is the master of her court. She has to deal with all stakeholders of the judicial system. whereas the principal district judge has to run the administration of the entire district. IAS officers are well trained in this area. Likewise, the judicial academies will need to focus on this aspect of personality development. A judge must possess good communication skills. As we go forward with live streaming of cases, of court proceedings, this may help a judge to conduct themselves in a dignified manner in the court. What you say in court now reaches out not merely to the 50 lawyers in your court, but 5 billion people across the world. Inculcating leadership qualities may also help in addressing the issue of trust deficit. In charting our course for judicial reform, there are several areas of concern beyond adopting technology for greater efficiency, and that's the next part of my presentation. In a country as diverse as India, accessibility, inclusiveness, and opportunity are three difficult paradigms to knit together. All social institutions have the responsibility to work towards blending these three qualities into one. Courts can contribute to this aim in a major way. It is imperative that every level of the judicial system is accessible, litigant-friendly, and inclusive to persons from all sections of society. The physical and digital architecture of courts must be inclusive as a matter of conscious design. The step towards e-filing is not only a means for achieving greater convenience and offset the environmental cost of paper, but also to make them accessible for persons with visual disabilities. Instead of printing and scanning their submissions, we have to get to a point where the default position entails lawyers filing PDF documents as they are prepared. The current practice of printing and then scanning documents is a futile and a time-consuming process that does not serve any purpose. We have to devise a practice of using digital signatures or requiring signatures only on the last page of paper books in order to ensure that lawyers do not feel compelled to print and then scan paper books because of the signature requirement. Wherever visual captchas are used to access any information, text-based captchas must also be provided. In transitioning to hybrid systems of hearing, we must ensure the availability and closed captioning and sign language interpreters. Court websites must have clearly labeled buttons and calendars to select dates. They must be accessible. Judgments and orders must be published in an accessible format without improperly placed watermarks. I can't tell you how annoying it is in the Supreme Court when you get High Court judgments which have bold watermarks. You can't read what is written by the judge on the page on which it is printed. So imagine how more difficult it is for a person who has visual disabilities in reading these judgments. We need to begin digitization by digitizing the lowest levels of our judiciary. We are digitizing old cases, but we must now digitize present cases. Otherwise, 5 years down the line, we'll be again left with a backlog of cases which we have to still digitize. Several infrastructural interventions are necessary in our physical courtrooms to make them accessible for marginalized groups. Courtrooms should ensure the presence of ramps and adequate support for persons with disabilities. We must have vulnerable witness courtrooms. Recently, under order which was passed by me, we have appointed a former Chief Justice of the High Court of Jammu and Kashmir, Justice Geeta Mittal, who was looking after this project for the whole country. Microphones and speakers must be installed in courtrooms. Furnishings must be suitable to eliminate the echo effect that disproportionately impacts persons with hearing impairments. The E-Committee is currently working with a dedicated group to receive inputs on specific interventions that can be made to make the judicial ecosystem accessible. It would be beneficial for the cause of justice at large if these efforts are integrated across all high courts and district courts. As women interact with the judiciary as lawyers and litigants, we must be mindful of the architecture of our physical spaces that are designed to exclusively cater to men. When I was an administrative judge for Kolhapur years ago, we realized that there was no bathroom for women. So the young judicial officers came and told me that we use the toilet when we leave home early morning, and our next interface with the toilet is when we go home late in the evening. That was the state. And I'm not talking of 50 years ago, just 10 years ago. So as administrative heads of our respective courtrooms,
It is all of our responsibility to ensure that courts provide separate washrooms for women, disabled persons, and transgender persons, functioning creches, child care spaces, and waiting rooms for pregnant and elderly persons are welcome initiatives for creating a truly inclusive space. People from marginalized communities like Dalits, women, LGBTQ persons may lack adequate access to secure their rights and entitlements, including avenues to obtain legal recourse. Women are mostly kept out of family matters such as land and company deals. Being disowned by family members, transgender persons also face this barrier. This can be remedied by gearing our legal aid institutions to be cognizant of the specific needs of these communities. The Tamil Nadu Judicial Academy recently sought to create awareness of harmful stereotypes and biases against LGBTQ persons that courts and judicial office orders may consciously and unconsciously perpetuate. While these might seem like small steps in the mammoth exercise of judging, they go a long way in restoring the faith of people in its justice system as a median for change. As judicial officers, we must be cognizant of the gaps in our perception of reality and that of marginalized groups about us. When litigants from the LGBTQ community plead their cases before us, we must be conscious to avoid issues of misgendering them, not using their preferred pronouns or chosen names, or using derogatory language that is rooted in harmful stereotypes. In instances of sexual harassment, the process is often the punishment for the complainant. In conducting criminal trials, the judge must step in to correct the iniquities in society and provide a safe space for women and children to testify. A code to address sexual harassment in courts must also be formulated and adequately publicized. Notably, the Karnataka High Court is one of the first in seeking separate hostels and accommodations for transgenders in higher educational institutions. Courts in Karnataka have also sought to bring about several progressive changes by guaranteeing the access of welfare schemes to LGBTQ persons who are otherwise exclusive from the heteronormative mold. Conscious steps towards inclusiveness and accessibility paves the way for new opportunities, not just for the stakeholders, but also for the judiciary to effect change in society. In discussing digitization and reforms, I would be remiss if I did not share a few thoughts on one of the most potent criticisms that have been leveled against the judiciary, its track record in upholding constitutional principles of liberty. The importance of the freedom of personal liberty under Article 21 has been underscored by the judiciary ad nauseum. However, the true import of these words can only be discerned in practice. The oft-cited rule, bail, not jail, is one of the most fundamental rules of the criminal justice system. Yet, in practice, the number of under-trials languishing in the prisons in India reflects a paradoxical situation, where the provisions for bail meant to preserve personal liberty have been manipulated to deny a person's release. India's National Crime Records Bureau report published in 2020 shows that the number of under-trials languishing in Indian prisons is greater than the number of convicts. Out of a total of 4.66 lakhs prisoners, about 3.24 lakh prisoners are under trials. About 71.2% of prisoners have been confined for periods up to 1 year. 14.6% under trial prisoners have been confined for up to 1 to 2 years. 7.9% for up to 2 to 3 years, and 6.45% of over 3 years. Criminological studies demonstrate that an accused's marginalization and deprivation in society is compounded manifold when it intersects with the realities of the criminal justice system. A demographic survey of Indian under-trial evinces that marginalized sections of the society are incarcerated in disproportionate numbers. About 69.4% of the under-trials are either illiterate or have been educated only up to class 10. The scheduled castes are overrepresented. and account for over 21% of the under trials, when they make up only 16.6% of India's general population. Similarly, the scheduled tribes make up for 10.5% of the under trials, while they account for 8.6% of the population. Muslims constitute 18.7% of the under trials, while their share in the population is 14.2%. Other religious minorities constitute 7% of the under trials. About 1,212 women under trials are accompanied by 1,049 children in our jails. The judiciary's commitment to the constitutional promise of personal liberty has to be bolstered in two significant ways. First, by addressing the quantitative delay in disposing of criminal matters, particularly bail petitions. And second, improving the quality of justice that is dispensed with by courts. On the first factor of delay, the number of bail applications pending before the high courts is 1,14,835 and a staggering 1,90,703 before the district courts. In 2020, a study found that the average time taken for the disposal of bail matters was determined at 10.321 days. Yet, the average pendency of bail matters was found to be 4,668 days. These shocking figures demonstrate the farcical reality to Lord Denning's imploration to the judiciary to give the utmost priority to cases concerning liberty, especially when the law presumes their innocence. While these figures may seem like simple numbers, these are valuable days lost in the life of a person. Deprivation of liberty for even a single day is a day too many. Judges would do well to remember that the authority of the judiciary is associated not with the prestige of the office we hold, but the quality of the justice we dispense. What good is our authority if we cannot apply the nuances of the law to give justice to the deserving? What is the value of the rich jurisprudence developed by the Supreme Court since the independence of our nation to preserve and protect the liberty of each individual if that does not come to the aid of the individual at the grassroots level? And what value is our rich jurisprudence if the jurisprudence only subserves the cause of the rich? Often, judicial decisions on personal liberty are a result of a template-based approach, where judges simply glance over the offenses involved in the case and then render their decision on bail. This has resulted in judges simply reproducing case law without interpreting or analyzing the legal provisions or the facts of the case. Not only is this process against the very tenets of decision-making, but it also violates the trust and faith that is reposed by the individuals of our country in the judiciary. There is also a brooding sense of fear among courts of the first instance on how the grant of anticipatory bail or bail will be perceived at higher levels. There is a trust deficit today. Trust deficit about the district judiciary in the high courts, as a result of which elementary cases where bail should be granted by the district courts, bail is never granted and those matters land up in the high courts. Cases where bail should be granted by the high courts, which don't get disposed of in the high court, or get denied in the high courts and land up in our lap in the Supreme Court. There is this grave distrust, this culture of distrust which we must end. And my sincere request to all the members of the Karnataka District Judiciary is, please do your duties with a sense which rises above this fear about granting bail and anticipatory bail in deserving cases. This results either in rejection of bail or grant of bail on extremely onerous conditions, both of which are undesirable outcomes. In the words of Justice Krishna Iyer, the best guarantee of presence in court is the reach of the law, not the money tag. This practice at the district courts sets in motion a vicious cycle where litigants are trapped in a judicial whirlpool, moving to the higher courts and navigating layers of bureaucracy, touts, delay, and corruption. This affects the poorest of our country the most, who not only suffer at the hands of the police, but also caught in this judicial web without adequate economic resources or knowledge to cut through the red tapeism. We've been confronted in the Supreme Court of criminal appeals pending for 15 years where bail has been denied. 302 convicts who are in jail for 20 years with the appeal still pending in the High Court and still no bail having been granted. We must realize that the values that have been placed in the care of the judiciary, specifically at the district level, chart the course of a litigant's life for months, if not years to come. The access to the district judiciary for the grant of bail should not just become a mechanical process where you take an order of rejection only to go to a higher court. We must have actual justice being delivered by the district judiciary as well. Only this realization would help to rid ourselves of the colonial mindset of referring and treating the district courts as the subordinate judiciary in the hierarchy and in practice. I implore all of you to instrumentalize the ICT tools on NJDG to monitor the pendency and disposal of cases, especially in matters of personal liberty. Issues of personal liberty must be adjudicated with a fierce sense of urgency. So much as we discuss technology today, please also discuss what you need to do to bolster your efforts to ensure that we truly protect personal liberty beyond merely the text of the Indian Constitution. In conclusion, let me tell you about Harper Lee's book, To Kill a Mockingbird, which was an awakening on discrimination's impact on the criminal justice system. It exposed societal fissures that often reflect in the tyranny of the law. Atticus Finch, the dynamic defense lawyer, was representing an African-American man who was falsely accused of rape and condemned, even before he was subjected to a fair trial. As Atticus wrestled with the society and biases of the jury, he expressed a profound hope in the judiciary. He said, "But there is one way in this country in which all men are created equal. There is one human institution that makes a pauper the equal of a Rockefeller, the stupid man the equal of an Einstein, and the ignorant man the equal of any college president. That institution, gentlemen, is a court." He said it can be the Supreme Court of the United States or the humblest Justice of Peace court in the land, or this honorable court which you serve. Our courts have their faults, as does any human institution. But in this country, our courts are the greatest levelers. And in our court, all persons are created equal. These haunting words are an expression of the immense responsibility that a judge dons along with their robes. Callousness with the liberty of the poor or the ideologically dissident is an abdication of the highest purpose that our job will serve. As a judge of the Supreme Court, I hear close to 60 cases every day, which are a combination of civil and criminal and commercial and constitutional cases. Those are the few individuals with the economic wherewithal to move the apex court. Effective justice from a litigant's perspective is realized at the preliminary stages of the judiciary, as opposed to one who has navigated the tribulations of the system and received a relief at the final stage of the judicial process. It is our collective task to strengthen the roots of our judicial system. I'm confident that the sessions over the next 2 days and the strong sense of purpose of the Karnataka State Judicial Officers Association will create a permanent platform to achieve this aim. I thank you very deeply from the bottom of my heart for all the lovely mementos and the shawl and the accolades which I have received this morning. Since last evening, I have received quite a few garlands from the High Court and from the members of the district judiciary. I was just thinking, I turned 62 years ago in the pandemic. Ordinarily, at least in Maharashtra, I'm sure the same in Karnataka as well, when you turn 60, you exchange garlands once again. So I was just thinking to myself, and all these beautiful garlands were given to me. I said, I wish Kalpana was with me on the stage. We could have perhaps made up for the lost ground of the last 2 years when the pandemic denied me the joy of exchanging garlands with my lovely spouse, who's also with me, thanks to the invitation of the High Court. Thank you very much. Yes.
Well, ladies and gentlemen, you would all agree with me that was indeed a highly visionary, thought-provoking, and of course, inspiring inaugural address. So let's give a huge round of applause and thank Honorable Dr. Justice Dhananjay Chandrachud for his presence and the inaugural address. Thank you, sir.
Ladies and gentlemen, we have come to the concluding part of today's program. I request Shri Jai Prakash GR, General Secretary, Karnataka State Judicial Officers Association, to propose vote of thanks.
Honorable dignitaries on the dais and off the dais, distinguished invitees, respected judicial officers, members of print and electronic media. On a very important occasion like this, it is my privilege to propose vote of thanks on behalf of Karnataka State Judicial Officers Association to the dignitaries on the dais and off the dais. The success of today's inaugural function of 20th Biennial State Level Conference of Judicial Officers of the State of Karnataka is entirely dependent upon the gracious presence of the dignitaries and distinguished invitees. Honorable Dr. Justice Dhananjay Y. Chandrachud, Judge, Supreme Court of India and Chairperson, E-Committee, Supreme Court of India, has been kind enough to accept our invitation to inaugurate 20th Biennial State Level Conference of Judicial Officers of State of Karnataka. My Lord, your thoughts have enlightened our minds and souls and indicates a new path for us to tread. On behalf of Karnataka State Judicial Officers Association, I express my heartfelt thanks to Your Lordship, Honorable Dr. Justice Dhananjay Y. Chandrachud, Judge, Honorable Supreme Court of India. Honorable Shri Basavaraj Bommai, Honorable Chief Minister, State of Karnataka, has been kind enough to accept our invitation to be the guest of honor of today's inaugural function. Honorable Chief Minister, besides being the Finance Minister, has also extended all the cooperation for conducting these 2 days biennial conference. In his absence, on behalf of Karnataka State Judicial Officers Association, I express my sincere gratitude to Honorable Shri Basavaraj Bommai, Honorable Chief Minister, State of Karnataka. In the absence of Honorable Shri Justice Dinesh Maheshwari, Judge, Supreme Court of India, on behalf of Association, I also express a deep sense of gratitude to Honorable Shri Justice Dinesh Maheshwari, Judge, Supreme Court of India, for his message for the success of this conference. Honorable Shri Ajikotira Somaya Bopanna, Judge, Supreme Court of India, has been kind enough to accept our invitation to grace the occasion of inaugural function. My Lord, you are always an inspiration for all judicial officers. Your Lordship's pleasant personality itself is an example for all the judicial officers to mold themselves. On behalf of Karnataka Judicial Officers Association, I express my sincere gratitude to Honorable Shri Justice A.S. Bopanna, Judge, Supreme Court of India. Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India, has been kind enough to accept our invitation to grace the occasion of inaugural function. My Lord, you were always a guiding spirit for all of us, and your thoughts expressed today will be surely going to encourage in our future endeavors. On behalf of Karnataka State Judicial Officers Association, I express my sincere gratitude to Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India. Honorable Shri Justice Rituraj Avasthi, Chief Justice, High Court of Karnataka, has been kind enough to accept our invitation to preside over the inaugural function. His Lordship is a visionary and has supported the association in every step in organizing this conference. Without His Lordship's initiative, guidance and support, this conference would not have been materialized. On behalf of Karnataka State Judicial Officers Association, I express my sincere gratitude to Honorable Justice Sri Rituraj Avasthi, Chief Justice, High Court of Karnataka. The gracious presence of former Lokayukta Honorable Justice Vishwanath Shetty, former judges of Honorable High Court of Karnataka, Honorable Justice Srinivas Gowda, Honorable Justice Sri C.R. Kumaraswamy, Honorable Justice B.A. Patil, and all other dignitaries has added value to this conference. I extend my sincere gratitude to all the former judges of Honorable High Court of Karnataka. The presence of all the sitting judges of Honorable High Court of Karnataka has also added value to our conference. On behalf of Karnataka State Judicial Officers Association, I extend heartfelt thanks to all the sitting Honorable Judges of High Court of Karnataka. Our association is immensely grateful to Honorable Registrar General and all the Honorable Registrars of High Court of Karnataka for guiding us in conducting this conference. On behalf of office bearers of the association, I express my heartfelt thanks to Honorable Registrar General Sri T.G. Shivshankara Gowda and all the Honorable Registrars of Honorable High Court of Karnataka. Many former district judges who are all members of the district judiciary are also present, and on behalf of Karnataka State Judicial Officers Association, I express deep sense of gratitude to all the former judges of district judiciary. On behalf of association, I extend a deep sense of gratitude to Sri Mallan Gowda, President of Bar Association, President of Karnataka State Judicial Officers Association, who has taken lead in organizing this event. I express deep sense of gratitude to all the principal district judges, unit heads, and all senior judges, and all the delegates who have traveled all the way from all long distance after completing their working day yesterday, and who are present in the today's function. On behalf of association, I express deep sense of gratitude to all the delegates. I also express my sincere thanks to the officials of Finance Department, Revenue Department, Police Department, Health Department, the Vice Chancellor of GKVK and authorities of GKVK, and staff members of Honorable High Court of Karnataka and City Civil Court who have assisted and are assisting in this organizing this conference. I also extend my sincere thanks to print and electronic media for covering this event. And at the end, thanks to all those who have directly and indirectly helped us in organizing this conference and making this inaugural function of this conference a successful one. Thank you, one and all.
ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನ ಸಮರ್ಪಿಸಿದಂತಹ ಶ್ರೀಯುತ ಜಯಪ್ರಕಾಶ್ ಡಿಆರ್ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
Well, ladies and gentlemen, please note the inaugural session will conclude with the national anthem, but immediately after the national anthem, there will be a photo session with the office bearers. Adada nantara, yavade break ilde session irutte delegates. So kindly note that. Immediately after the photo session, the conference will start because of the paucity of time. Now I would request all of you to kindly rise for the national anthem. Rashtragite.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे